I'd like to introduce my colleagues, Patrick Haynes and Caitlin Poe. Patrick is a partner with our litigation section. He focuses his practice on handling all manner of disputes that arise from business competition and regulation. He has represented businesses and individuals in government and corporate investigations in matters involving securities and banking regulation, antitrust, conspiracy, public corruption, wire fraud, tax disputes, environmental laws, and the Foreign Corrupt Practices Act. More relevant to today's topic, Patrick serves as Deputy Counsel and Chief Ethics Counsel to the law firm. He has served as an adjunct professor at the University of Richmond and Washington and Lee University, and he has conducted many approved continuing legal education classes on legal ethics topics. Caitlin is also a partner with our litigation section. She is a trial lawyer and regulatory advisor who represents criminal and civil clients with a particular focus on representing clients adverse to the state or federal government. Her experience includes criminal and civil cases involving securities regulation, intellectual property, consumer protection, environmental compliance, and allegations of healthcare fraud and financial fraud. Caitlin, please take it away.
Thank you so much, Lauren, and thank you so much to everyone who is here this morning. Welcome, and we are going to walk through some ethics hypotheticals with some answers and hopefully some helpful tips and advice for those of you who encounter these situations. So our first case is you represent your employer, Alpha Company, in a business litigation that has dragged on for a long time, and the trial date is still a year away. Opposing counsel is difficult to deal with, first time for everything, and refuses to discuss settlement. Your CEO is frustrated at the slow pace and is anxious to resolve the dispute so that the company can focus on its business. She asks you whether she can contact the opposing party directly to discuss settlement. Can the CEO contact the other party? Patrick.
Good morning, Caitlin, by the way. And I made sure to get coffee for ethics, which is highly recommended. So the question, can the CEO contact the other party? We don't have a poll for this one. We are going to be doing polls for some of the others after we warm you up. So you can practice on this one without everyone seeing whether you were in the yes camp or the no camp. The answer here, the correct answer is yes, the CEO may contact the other party. Of course, the questions here from an ethics point of view are going to be, what can you as the attorney say to the CEO regarding whether they should make that contact, and what you should say about what your CEO should communicate with the other side. It is clear in all states that matter to our group here that you may advise the CEO that she is not prohibited from contacting the other party. Where the rules differ is in different states in the legal ethics opinions and guidance offered by the different state bars is to what extent you may suggest, as some of them put it, or direct the content of your client's communication with the other side's representative when they are not accompanied by counsel. The second issue that we'll discuss in these hypotheticals is what you may advise about what the CEO may say in that communication, and that varies widely amongst the jurisdictions. But the simple answer to the question is that you may advise the CEO she's not prohibited from contacting the other party. Now, it would be competent to advise her about the risks of such communications, including the possibility that your client may make statements or provide information to the other side that might hurt the company's case or disclose more than you might prefer that the other side understands about the company's case. But you don't have an ethical obligation to try and prevent her from talking to the opposing party. Now, your discussion about those communications should be conducted with care. And the reason of this is an interplay between rules 4.2 and 8.4. 4.2 is the non-communication rule, which prohibits a lawyer from communicating about the subject of the representation with a person that the lawyer knows to be represented by another lawyer in the matter. And Rule 8.4, of course, makes it that you can't use somebody else to assist you in an act that would violate your own duties. It is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through the acts of another. So you can't use the CEO to make a communication basically on your behalf. Can we switch to the next slide? And of course, comment 4 of the North Carolina's version of the rule makes that clear. Now, the comment to 4.2 does go on to note a lawyer is not prohibited from advising a client of an action that the client is lawfully entitled to take. Comment 4 to Virginia's version of the rule makes clear and applies it in the setting of our hypothetical that parties to a matter may communicate directly with each other. And again, because a lawyer is not prohibited from advising a client of an action that the client is lawfully entitled to take, bars have found that a lawyer may advise the client that they may make that communication to a representative of the other side. Now, what a lawyer may advise his client concerning those communications varies among the states. Some states actually prohibit the lawyers from suggesting that their clients communicate directly with opposing parties who are represented, or from drafting discussion points or documents relating to those communications. Among those are New York, Massachusetts, and California. Can you go to the next slide? The ABA formal opinion on the topic goes beyond what is permitted in Virginia and North Carolina, and not only approves the lawyer advising his client to communicate ex parte with a represented adversary, but also of the lawyer advising the client about the content of the communications that the client proposes to engage in. This can even include, under the ABA's opinion, reviewing and revising a letter or a set of talking points that the client has drafted to use to guide the discussion. And that's also the approach taken in the restatement of the law governing lawyers. Can you move to the next slide, please? And can you skip to the next slide also? Now, the ABA opinion, which was 20 years ago now, also does caution against lawyers overreaching in such circumstances. And some of the examples that are given of overreaching include assisting the client in trying to secure from the other person who is represented an enforceable promise, or trying to get them to disclose confidential information, or trying to get the represented person from making some sort of admission against their interest without their opportunity to seek the advice of counsel regarding whether they should make that statement. So under the ABA guidance, they say to prevent that kind of overreaching, that a lawyer must advise your client to encourage the other party to consult with counsel before entering into any binding obligation, making any admission, or disclosing anything that would be confidential. And if counsel has drafted some proposed agreement for the client to deliver to the represented party, before it is signed, counsel should include in the agreement conspicuous language on the signature page that warns the other party to consult his lawyer before they sign the agreement. So that is the picture under our case 1. Caitlin?
All right, so moving on to case 2, same facts, but the question this time is, can you, the attorney, assist your CEO in preparing for those direct communications with her opposing executive?
Caitlin, you want to hazard a guess?
You know, it's hard for me to imagine that you can't advise your client in what they're about to do. But, on the other hand, you can't do indirectly what you're prohibited from doing directly.
I like it. I like it. The lawyerly answer is it depends.
It depends. It always depends.
And it does. It does. The answer is that it does depend. In this case, it depends on which jurisdiction is governing your conduct as an attorney. If you can go to the next slide, the answer is yes. In the District of Columbia, you can provide very detailed guidance in preparing your client for those direct communications. In Virginia and North Carolina, the answers would be very different. So this is an example of my prior kind of key point in talking about case 2, that what you can do varies very widely, all the way from drafting their bullet points to, as in DC, to in Virginia, where you are under an existing LEO to provide no specific instructions regarding that communication. The DC rule is the subject of a recent opinion of the DC Bar, DC Bar Opinion 385. The DC version of Rule 4.2 is substantially the same as the rule in Virginia and North Carolina, but the similarities end there. Comment 2 to the DC rule states that a lawyer is not prohibited from advising a client concerning a communication that the client is legally entitled to make, provided that the client communication is not solely for the purpose of evading restrictions imposed on the lawyer by this rule. So sometimes I think of that as the will someone rid me of this meddlesome priest rule. You can't simply say it would be a good thing if somebody called up the CEO on the other side and told him his darn lawyer is giving him the wrong answer. Can you go to the next slide? The DC Bar Ethics opinion acknowledges that the comment in DC permits a lawyer to respond to a client's proposal for party-to-party communications and to answer the client's questions regarding the communications. But the opinion goes even further, and it states that the rule permits a lawyer to suggest that the client should communicate directly with the opposing party if the lawyer concludes that making that kind of direct communication may advance the client's objectives, for example, to get the case settled. Also, according to the DC Bar opinion, advising a client concerning a communication with the opposing party includes assisting the client in preparing for those communications. So in DC, they're saying that part of that advice includes providing your best assistance as to what they should say. Essentially that, you shouldn't just have to hint or warn them about things they shouldn't say. They permit you to go further and advise and assist the client in preparing for the communications. Can you go to the next slide? Now, neither the North Carolina rule nor comments to that rule address what, if any, assistance the attorney may provide to the client in preparing for direct communications. So the prudent position there is that the attorney may not do so. And again, comment 4 to the North Carolina rule, Kaylin, along the lines of what your cautionary prudent position was, that the comment does say that a lawyer may not make a communication prohibited by this rule through the acts of another. So in the absence of clear guidance that you could assist the client in preparing those communications, I think you'd be proper to not take that position, to not actually help them draft the bullet points. As for Virginia, comment 4 to the rule merely notes that the parties to a matter may communicate directly with each other. And there's a legal ethics opinion, number 1755 in Virginia, that goes further and states that while a party is free by his own initiative to contact the opposing party, and again, by his own initiative, a lawyer may not avoid the dictate of Rule Point 2 by directing his client to make contact with the opposing party. So again, this wide range of Suggesting is okay, but not directing, because that's prohibited. Can you go to the next slide, please? As for assisting the client in preparing for those, in Virginia, the rule as articulated in LEO number 233 states it's improper for an attorney to indirectly communicate with a party adverse to his client, giving specific instructions to his client as to what communications to make, unless counsel for the adverse party agrees to such communication. All right, Caitlin, next.
All right, so this is case 3, and I think that this is going to be a polling question. So everybody listen closely, because we're about to get your thoughts on this. So you are employed as in-house counsel at Alpha Corporation. The company's published email policy prohibits employees from using its email system for personal matters. So no personal matters on company email, and cautions that Alpha reserves the right to monitor and review emails sent through that system. You suspect that a former employee who is suing Alpha for wrongful termination used the company email system to communicate with a lawyer before she left. Do you violate the former employee's attorney-client privilege if you retrieve and use emails between the former employee and his lawyer, her lawyer, which is on the company email system? So the ethics question number 3 is up. Do you violate the former employee's attorney-client privilege if you retrieve and use emails between the former employee and lawyer? Yes or no?
I think we're trying to give people about 30 seconds to answer the question. And it is important that you answer each question to get your credit for the CLE. So please give an answer. There are no bad answers. There is one that is more correct than the other.
I was about to say, there's no bad answers. There's a wrong answer, but that's okay. We're here to learn, right?
Yes. And I think this is something that a lot of the listeners have probably dealt with. It's a question that very frequently comes up in litigation. All right, let's see. All right. Do you want to give the results, Caitlin?
All right, so this was pretty divided. We had 61% of people said, no, you do not violate the former employee's attorney-client privilege by looking at the emails.
And I think under the specific facts that we have, the answer is no. The better answer is no. And of course, we have the benefit of basing the hypothetical on a specific case from the New York Superior Court in 2007. But there are some nuances to this and how you should analyze it if the issue comes up in your practice, which we'll discuss. The key here is just from thinking through the question is the required element. One of the required elements of an attorney-client privilege is that the speaker, in this case, the client, has to have a reasonable expectation of confidentiality in the communication. So that's the key element. Just as if you and a client just openly discuss something in a large crowd of people, the privilege may not attach, probably doesn't, because it is missing that element of a reasonable expectation of confidentiality. And this is applying that element in the context of work emails. In the case, before his departure, there was a doctor who had sued to recover $14 million in severance pay for a wrongful discharge. And before his departure, he had sent several emails to his lawyer using the doctor's work email address and through the hospital's email server. Now, in this case, the hospital had a published email policy provided that its system was for business purposes only, and that any emails sent were the property of the hospital, that employees had no personal privacy rights in their emails, and that Beth Israel reserved the right to access and disclose emails on the system at any time. Can you go to the next slide, please? So the court there identified that an expectation of confidentiality is the core of the attorney-client privilege. And because under these circumstances, the published email policy, the court held that the doctor had no expectation of confidentiality. And as a result, the privilege did not protect his emails through his work email to his lawyer. Now, I said partly for the people who had said yes, but also because I think it is accurate, is that the law regarding the privilege in this area has been evolving since that case decision. North Carolina has more recently than the decision, I think about 10 years ago, issued an ethics opinion that addresses, among other things, a lawyer's duty to advise his employer client regarding their ability to access employee email communications using the work email system. And that ethics opinion was informed by changes in the underlying law regarding the privilege. What the ethics opinion says is that the lawyer should first should familiarize him or herself with the law regarding identification, recovery, and production of employee email and related privilege issues. Only then can you advise your employer client about its rights and responsibilities here. Can you go to the next slide? And the case law from North Carolina and some other jurisdictions suggests that whether the privilege applies in the circumstances, again, like the court analyzed in New York, depends on whether an employee has a reasonable expectation of privacy. But this requires an investigation into a number of factors, including whether the employer has a clear and unambiguous policy regarding email usage and monitoring, whether that policy is effectively communicated to employees. So you need to determine, was it buried in the bottom of the manual that no one has got an assigned acknowledgement from the employees, whether the policy is adhered to by the employer, whether third parties have access to the employee's email account on the employer's system, even when or where the communication occurred. Was it late night when the employee was at home using his email as he or she is allowed to do? And whether the employee took affirmative steps to preserve the privacy of the communication. Can we go to the next slide? So in our hypothetical situation, if after analyzing the relevant case law and the facts, you're able to conclude with confidence and in good faith that the privilege has been waived, you may then read the emails and use them to represent alpha. I always advise that you should err on the side of caution if you are conducting this multi-factor analysis and some fact in it might be inconclusive or might be questioned. And if it's a litigation matter, the best course is just to preemptively seek a judicial determination of the waiver issue. Your client has the data, you can preserve it, and then you can go to the court and raise and resolve the issue before you taint your representation by looking at the email itself.
Very prudent move. All right. So case number 4. You are negotiating to become the first in-house counsel at a software company. You request and the company agrees that you will be released from liability to the company for malpractice, except for willful misconduct or a knowing violation of securities laws. You and the company sign a conforming employment contract containing such a release. Is there a problem with that?
Well, Caitlin, you know, if an ethics presentation phrases the question, is there a problem, that it's begging the answer. And the answer here is yes, there is a problem. Can you go to the next slide? This is one that is very simple, directly answered in a subsection of the rules. 1.8H that provides a lawyer shall not make an agreement prospectively limiting the lawyer's liability to a client for malpractice unless the client is independently represented in making the agreement. And remember, under our hypothetical, you are going to be the first in-house counsel at the software company. So in our hypothetical negotiation, there is no independent representation to advise the client whether it should do this or not.
All right. A straightforward answer. Amazing. Okay.
Amazing.
All right. So on to case number 5, and this is going to be our second polling question. So everybody at the ready to send in their answers. So here is our situation, case number 5. You are in-house counsel at a local trucking company. You have a meeting with outside counsel for the company to discuss an employee's workers' comp case. Outside counsel is accompanied by a summer law clerk in her law firm, who, according to outside counsel, has published a law review article on workers' comp claims in your jurisdiction. Is the conversation in this meeting protected by attorney-client privilege? And our options here are definitely yes, definitely no, or probably.
We'll give people some time here, about 30 seconds, to answer the question. And don't forget that you need to answer every question in order to get your CLE credit.
This is ethics credit. So this is good stuff. You got to get that. Definitely don't want to sit through this and then not get the credit for it. That's for sure.
I have a number of volunteers who just attend these, even when they've met their credit for the year. All right, we have 68% saying probably, Caitlin.
All right. Seems like a rational answer given the nature of these questions.
It does. And while it is the correct answer here, I might be even stronger under our facts and say almost certainly. And the reason is, again, in our hypothetical situation, the summer law clerk has more expertise even than one might normally expect of a law student in the particular area, which strongly suggests the answer, because the answer here turns on whether the law clerk was a bystander or was of assistance to the lawyer in providing legal advice. There's no privilege if a law clerk or anyone else who is a non-lawyer in the room was only an observer. Privilege attaches if the lawyer used the law clerk or other non-lawyer to assist the lawyer in providing legal advice to the company. As stated in the restatement, privilege extends to communications to and from the client that are disclosed to independent contractors retained by a lawyer, among others, such as an accountant or physician retained by the lawyer to assist in providing legal services to the client and not for the purpose of testifying. So that's just an example, but it also extends to paralegals and others working with the law firm. Again, if they are there to provide assistance to the lawyer in providing legal advice or services. Can you go to the next slide? What is important about this, and that law firms often emphasize and make sure in their summer programs or programs with law clerks, is that there is importance to the firm or in the case of a corporate firm or department. And remember, in-house legal departments are treated under the rules as a firm, just as a law firm. So there's importance to train law clerks regarding confidentiality. Even if they're going to law school, it's important to exercise our supervisory responsibility to train them. Under Rule 5.3, with respect to a non-lawyer employed or retained by or associated with a lawyer, a principal, and a lawyer who individually or together with other lawyers possesses comparable managerial authority in the law firm or organization, shall, not may, but shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct is compatible with the professional obligations of the lawyer. And if you have direct supervisory authority over the non-lawyer, you have to make reasonable efforts to ensure that the non-lawyer's conduct is compatible with the professional obligations of the lawyer. And you can go to the next slide. It would actually be a violation of the rules if one has not properly executed those responsibilities. So this is one reason it's important to go through the training in your in-house department with law clerks, or if you're in an outside law firm, and as just part of your routine supervision of law clerks, to emphasize to them what they're doing there and what their duties of confidentiality are. Caitlin?
Makes sense. I will say, based on my experience here, I do think if you tried to argue to a judge that a law student busted the privilege, a judge is probably going to throw you in jail for that argument. So, you know, but all the same, good points, especially emphasizing to them the importance of confidentiality. It's a good learning tip for life. All right, so on to case number 6. In this one, you work in the legal department of a bank and represent the bank in a complex loan transaction. The borrower's counsel, in an effort to keep his client current concerning the negotiation of the loan documents, copies her on all of his emails to you. The loan negotiations have been amicable, and to communicate more efficiently, you reply to the emails from the borrower's counsel by hitting the Reply All button. The borrower's counsel has not expressly authorized you to communicate with his client in this way. Is it ethical for you to reply all? This is something that has happened to me, Patrick.
And I think it's happened in increasing frequency to many of us over the last 10 years. The answer in North Carolina is a clear one. We didn't make this a polling question, but the answer in North Carolina is no. But this is an issue that's animated the legal ethics committees over recent years. And some have revisited their view of this question. And I think in part that's just a reflection of the widespread use of email and that it does come up a lot more frequently. The issue arises, no surprise, under the prohibition of direct contacts with represented parties that we've already discussed in our earlier hypothetical, the no contact rule. So I won't repeat the rule. You know what it is. The issue then, if you can go to the next slide, the issue becomes whether in this circumstance, one, it implies consent by the lawyer who initiates the email chain for you to reply all and thereby communicate directly with his client through that reply. And if it is implied consent, whether that will be recognized or whether the jurisdiction says, no, you have to have express consent because of the language of 4.2. Several states have considered the propriety of implied consent to simultaneous communications by lawyers with represented persons. One example outside of the email context is the situation where lawyer A was conferring with her client outside of court, opposing lawyer B approaches them. Lawyer A initiates a conversation with lawyer B about an issue. I think in the case, it was whether the lawyer should call an elderly witness, the client's mother, to testify. The client interjected with her own comments about the frailty of the witness, and lawyer B responded to those comments. Can you go to the next slide? The bar committee there found that there was no violation by lawyer B making that communication because lawyer A had given implied consent to the communication with her client. And they noted that lawyer A had initiated the substantive conversation in the hallway, that lawyer B's communication was in direct response to that inquiry, and that the lawyer didn't attempt to step in and stop the communication. Both that opinion and a New York ethics opinion leave open the possibility that consent to reply all email communications with opposing counsel and their clients may be implied. But they also caution that the safest course is to obtain express consent from opposing counsel before doing so. The next slide, if you can go to the next slide, North Carolina considered that issue in a formal ethics opinion in 2012. It acknowledged the New York and California ethics opinions that authorized or that found that there was implied consent to a reply all email communications. But the North Carolina bar still concluded that Rule 4.2 requires the express consent of opposing counsel to such communications. Now, as I had said, I think in the outset of this, this is an issue animating the many bar committees to look at this issue. And Virginia last year issued an opinion going the other way, accepting the implied consent theory in a specific factual scenario. But so while I would say that there's possibly a trend towards recognizing the implied consent here, the better side, and certainly the side in North Carolina, the more prudent side, is not to do that without express consent. Caitlin?
Interesting. I do wonder if the ethics committee took that up again. 2012 wasn't that long ago, but I think our relationship with these guys has changed a lot since then. So I wonder if it would come out the same way. But probably the safest course is also to not copy your clients on emails that you don't want them to be communicated from. I know it's a pain sometimes to have to forward all of those, but boy, it's really easy to make that mistake. So we all have to be careful here in North Carolina until this issue is revisited, I guess.
Yeah.
All right, so on to case number 7. You have joined the in-house. Oh, and this is going to be another polling question. So get your mouse ready to answer this one. You have joined the in-house legal staff at Pharmaco, a large drugstore retail chain. Last year, another lawyer withdrew from the in-house legal staff at Pharmaco and joined a large law firm. You just learned that this law firm has, for the past 2 years, represented a company in the assertion of a breach of warranty claim against Pharmaco over asbestos contamination at a property that Pharmaco sold to this company. You also learned that the lawyer who left Pharmaco last year to join the buyer's law firm handled the sale of the property for Pharmaco, but does not appear to be personally involved in the law firm's representation of the buyer. Does the law firm nonetheless have a conflict of interest in handling the claim against Pharmaco? Yes or no? Make you pick a side on this one. I like it.
Yes, there's no middle ground. No it depends and no probably. So we'll give people 30 seconds to answer this question.
I don't like the idea of asbestos contamination at a pharmacy, but I guess we'll kind of glide past that part of the hypothetical and focus on the ethics part.
All right, let's see. The results here, overwhelmingly, 89% say yes.
Good
So
job, team.
I think our work is done here, Caitlin, because people seem to be getting it. The answer is yes. And the keys here are 3 steps in the analysis. This is a former client conflict, which comes under Rule 1.9. So the 3 keys are the attorney here formerly represented a Pharmaco in the matter, right? 2, that the matter is substantially related to the matter in dispute in the lawsuit. And 3, that the attorney's conflict is imputed to the whole firm. So even the fact that he's not involved in this case, once he's gone to the big law firm, that other lawyers are doing it, under the imputation rule, that conflict is imputed, and therefore consents would be required. So let's walk through this. The former conflict rule is under 1.9. A lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client gives informed consent confirmed in writing. So that's why I say the first question to be resolved is whether the lawyer who left Pharmaco's in-house legal department formerly represented Pharmaco in the matter of the sale of the property to the buyer. Now, the issue here is the lawyer's role within that legal department. As noted in the American Bar Association's formal opinion 99-415, direct involvement in the matter or a style of supervision that results in access to material information concerning a matter must be shown in order to establish that that formerly employed lawyer represented the organization in a specific matter. If you can go to the next slide, please. So under our facts, it could only be concluded that the lawyer was directly involved in the negotiation of the warranty that is at issue in the buyer's claims. So the lawyer did formally represent Pharmaco in the matter of the sale. In a larger legal department, there might be more factors to be considered. Was the person purely supervisory, not involved in the day-to-day? The ABA opinion goes into some of that, where someone is not directly representing. But in our facts, plainly, our lawyer did negotiate the warranty. So the second question to be resolved is whether the prior real estate purchase and in which the property was sold is substantially related to the breach of warranty claim being brought against Pharmaco. Comment 3 to Rule 1.9 in North Carolina fleshes out the meaning of substantially related. And this is taken from the ABA's model rule comment, which is not adopted in every state. In Virginia, we don't have any comment guidance on substantially related. But in North Carolina, comment 3 clarifies that a matter is substantially related for purposes of this rule if they involve the same transaction or legal dispute, or if there's otherwise a substantial risk that information that would normally have been obtained in the prior representation would materially advance the client's position in the subsequent matter. Next slide, please. In essence, under that analysis is a proxy for dealing with former conflicts, because instead of requiring the former client to actually disclose confidential information just to show that the lawyer has a conflict of interest, the substantial relationship test serves as a proxy. So you don't have to do that analysis. As the representations and warranties that Pharmaco made in the real estate sale that the in-house lawyer negotiated, the former in-house lawyer, are themselves a central issue in the breach of warranty claim, there's little doubt that the two matters are substantially related. So then that leaves the final question, which is whether the former lawyer's conflict is imputed to the rest of the law firm. Imputation comes under Rule 1.10, which provides that while lawyers are associated in a firm, none of them shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so under the rules regarding concurrent conflicts with respect to clients and former clients. The exception is that if a prohibition is based on a personal interest of the prohibited lawyer, then the prohibition does not present a significant risk of limiting the representation of the client by remaining lawyers in the firm, then it may not be imputed. But those are different kinds of conflicts. Those go to the say personal bias of the lawyer, personal ownership interests, and the like. So in our case, this conflict would be imputed. Can you go to the next slide, please? Rule 1.10, and this is a question that frequently comes up. Well, this lawyer is not going to be involved in the case. Can we just put a screen around him and therefore avoid the existence of a conflict? Rule 1.10 does not provide for a unilateral decision by the firm to screen the former Pharmaco lawyer from those involved in the buyer's claim. The only way that the law firm can avoid disqualification here is to seek and obtain waivers from both the buyer and from Pharmaco that would waive the conflict. And presumably Pharmaco, you representing Pharmaco, if you were to consider agreeing to that, you would presumably require as a condition of that the former pharmaco lawyer be screened from participating in it and from sharing any information that she gained during her representation of pharmaco. Now, the ABA formal opinion suggests that there might be circumstances where pharmaco might have an interest in granting consent. I think that might be a little bit wishful thinking, or a very unique set of circumstances where pharmaco in this instance would just agree to waive that conflict. But the ABA opinion points to some. For example, the buyer's claim may be in the midst of some protracted arbitration or mediation and negotiation. It may be that pharmaco believes that they're close to settling the matter, and that if they consent, that would avoid the need to substitute new counsel and wait for new counsel, a new firm, to get up to speed in order to potentially resolve the matter. But in any case, consent would be required here.
All right, so we'll move on to case 8, which is a little twist on this set of facts. So same circumstances, except this time, the former pharmaco lawyer had no personal involvement in the sale of the property for pharmaco and had no occasion to gain access to material information concerning the sale. She did, however, have general supervisory authority over the group of in-house lawyers at the company who handled property sales, including the sale at issue. And in that role, she had personally been involved in many similar types of matters for pharmaco. So under those circumstances, does her new firm still have a conflict of interest?
Well, as I sort of hinted in discussing case 7, under this one, I think that the pharmaco lawyer does not meet a test of a conflict, and the ABA formal opinion supports that analysis. So let me explain why. Here, the question arises under 1.9b of the rule as opposed to 1.9a. The ABA formal opinion notes that in this case, the lawyer who represented a former employer in similar types of matters, or a lawyer who had gained a general knowledge of the strategies, policies, personnel of the former employer, knows generally how they think, is not sufficient by itself to establish a substantial relationship between the current matter and matters in the legal department at the organization for purposes of 1.9a. The ABA opinion also says that general supervisory responsibility, such as that exercised by the head of the legal department, ordinarily is not by itself enough to establish that a lawyer represented his former employer in a particular matter, even if it is the same as or substantially related to a matter at the new firm. So because it's essentially that here that lawyer did not represent pharmaco in the matter. So because of that, you don't look to rule 1.9, you look to 1.9a, you look to subsection B. Can you go to the next slide? So subsection B applies in the situation where the former in-house lawyer did not personally represent the organization in the same or substantially related matter. So in that case, what matters is, does pharmaco have interests that are materially adverse to those of the buyer? Here it clearly does. And the lawyer acquired confidential information that's material to the matter. Under the facts here, it appears the former pharmaco lawyer never gained any material information concerning the sale. She only had a general knowledge of strategies, policies, and personnel of the company. The ABA opinion does note that while some courts have continued to consider a general knowledge of the client's organization, practices, and strategy to constitute protected information, others have rejected that concept. Which inconsistency the ABA committee, in its opinion, reconciles by observing that whether the lawyer has protected information depends on the facts and circumstances of each particular case. Can you go to the next slide, please? So here, the former Pharmaco lawyer and her new firm would certainly have to consider carefully whether, notwithstanding the fact that she appeared to be not involved in the underlying sale of the property, she acquired any material information in the course of her duties that she would be precluded from using or from revealing under Rule 1.9c. Comment 4, by the way, describes the competing considerations that inform Rule 1.9 in this situation. I think we can all kind of sense this tension because the Pharmaco lawyer appears to be pretty distant from this, and all they've really done is gone out into the world to make their money working for a new law firm certainly without planning to use any confidential information in the breach of warranty suit. But the competing factors here that sort of determine how this works is first, of course, the principle of loyalty, which is of paramount importance in the rules of professional responsibility. So the client here, Pharmaco, must be reasonably assured that the principle of loyalty to the former lawyer's client is not compromised. But second, the rule shouldn't be so broadly cast as to preclude other persons from having a reasonable choice of law firm and legal counsel. It shouldn't unreasonably hamper lawyers from forming new associations and taking on new clients after having left a previous firm. And the comment goes on to observe that today many lawyers practice in firms, that many lawyers to some degree limit their practice to one field and another. They move from one association to another several times in their careers. And if that concept of imputing that conflict to the entire law firm were applied with, as they put it, unqualified rigor, the result would be radical curtailment of the opportunity of lawyers to move from one practice setting to another, and the opportunity of clients to change their lawyers.
All right. So moving on to our next case, case 9. This one has to do with everyone's favorite press coverage of our cases. So in this situation, your company just obtained a substantial defense verdict in a lawsuit involving a well-known and well-liked local business personality. The litigation was particularly contentious, and the trial was covered in the local press. Your CEO and other executives are pleased with the result, but are displeased by the publicity that the case generated. The company's outside counsel is proud of the outcome, especially as most people in the local legal community did not think the case was winnable. As part of the firm's overall marketing efforts, her firm wants to spread the news of the victory on the firm's law blog. Does the firm need the client company's consent to do so?
This would be a tough call to handle, I guess, if I'm in-house counsel in this situation, or if I'm and I have a good relationship with outside counsel. I'd be proud of it myself. I know why you want to talk about it in your blog. The answer to the question is yes, they do need your company's consent to do so. And the reason for that is, and the key here is remembering that our duties as lawyers to maintain confidential information arising from our representation of clients is not limited to privileged information. So, here we're talking about a lawyer who wants to disclose what is, after all, a public record. It's not a request to disclose any privileged communication with the company, but it's still confidential information, and that we are not at liberty to disclose without client consent. The ABA model rule and North Carolina's rule, though in slightly different formulations, articulate this. The ABA rule is the lawyer shall not reveal information acquired during the professional relationship with a client unless the client gives informed consent or if the disclosure is impliedly authorized. And that's not our situation. In North Carolina, it's Rule 1.6a is phrased a little differently. It says the lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, et cetera, et cetera. Can you go to the next slide? The comments give more color to this. And in the ABA, they recognize that this is a fundamental principle in the lawyer-client relationship to maintain it. It's important because we want our clients to communicate fully and frankly with us, even as to something embarrassing or legally damaging. And as noted in the comment, the confidentiality rule applies not merely to matters communicated in confidence, but also to all information gained in the professional relationship that the client has requested to be held inviolate, or the disclosure of which would be embarrassing or would likely be detrimental to the client, whatever its source. Can you go to the next slide here? The ABA Lawyer's Manual on Professional Conduct notes the same thing and gives several case examples about lawyers being prohibited from revealing information, even though that information is available from public sources. If we can go to the next slide here. So under our fact, we've already articulated that the lawsuit, while the company is glad that it's over and glad that it prevailed, was against a local personality, and they weren't happy that they had to defend the lawsuit. So the last thing that our company really would want here is more publicity about the case, even though they prevailed. So the problem here is that the information is likely to be embarrassing or detrimental to the client if it is further publicized. So North Carolina has amended its Rule 1.9 recently in a way that's more liberal, that liberalizes that the permission and gives permission for a lawyer to use or disclose confidential client information when that information is contained in a public record. However, a subsection of the rule limits that to instances where the disclosure likely will not be embarrassing or detrimental to the client. And again, under the facts of our scenario, the client was embarrassed by the public airing of the dispute and therefore is likely to be further embarrassed if the lawyer were to publicize the case results on the blog.
And as Patrick and I know, when you represent clients, particularly in connection with investigations or enforcement actions, the best cases, the best outcomes are the ones where no one knows about it. And so this is something that we run into all the time. So always great to be in the local news, but not always an option when it's against your client's interests. Well, I see we only have a minute left. So I think that we'll probably wrap up here. If you had any questions for us that you weren't able to share in the chat today, please feel free to send Patrick or me an email. We'd be happy to follow up with you. Thank you so much again for joining us today.